Good afternoon. I want to welcome you to the House hearing of Children and Families. Mr. Secretary, will you call the roll?
Representative Franklin.
Here.
Representative Neely. Here. Representative Mayor.
Here.
Representative Beard.
Here.
Representative Bratton.
Here.
Representative Brown.
Here.
Representative Gannon.
Here.
Representative Hickner.
Here.
Representative Lauer.
Here.
Representative Newman.
Here.
Representative Nor. Here. Representative Vermillion.
All right, great. We have a quorum. Our first order of business is going to exec on two bills that we have listed. House Bill 1965 and House Bill 1822. So I move that House Bill 1965 be voted to pass. Any discussion? Seeing none. Secretary, please call the roll.
Representative Franklin.
Aye.
Representative Neely.
Aye.
Representative Meredith.
Aye.
Representative Beard.
Aye.
Representative Bratton.
Aye.
Representative Brown.
Aye.
Representative Gannon.
Aye.
Representative Hickner.
Aye.
Representative Lauer.
Aye.
Representative Newman.
Aye.
Aye.
Yes.
Representative Nor.
Aye.
Representative Vermillion.
All right. By your vote of 11 ayes and 0 noes, you have voted House Bill 1965 to pass. All right, our next bill is House Bill 1822. I move that House Bill 1822 be voted to pass. Any discussion? Okay, seeing none, Mr. Secretary, please call the roll.
Representative Franklin.
Aye.
Representative Neely.
Aye.
Representative Meredith.
Oh, yes, aye.
Representative Beard.
Aye.
Representative Bratton.
No.
Representative Brown.
Aye.
Representative Gannon.
Aye.
Representative Hickner.
Aye.
Representative Lauer.
Aye.
Representative Newman.
Aye.
Representative Nor.
Aye.
Representative Vermillion.
All right. By your vote of 10 ayes and 1 no, you have voted House Bill 1822 to pass. All right, thank you very much. Is Representative Swan here? All right, I'll just pause for just a moment. Let me get a feel for the room. Who is here today for House Bill 2055, Representative Swan's bill? All right, thank you. And then who is here to testify on House Bill 1968, Representative Anderson's bill? All right, thank you. Representative Anderson, we'll go ahead with you. Thank you so much. You may proceed when you're ready, Wendy.
Thank you, Madam Chairman. And committee, for the record, I'm Sonia Anderson. I'm state representative for the 131st District, which is Northern Springfield and North Central Greene County. Today I'm presenting House Bill 1968, which will strengthen Missouri's parental consent law when a minor is seeking an abortion. This language is identical to House Bill 81 that I presented to this committee last year that passed by a vote of 8-3. Currently, Missouri law says a parent must be involved in a life-altering decision of abortion, and my bill simply says that we want to make sure that the adult giving consent is one of the actual parents. Current Missouri law requires the consent of one parent before an abortion can be performed, but the system doesn't require the proof of identity for that parent. Strengthening the law to require a notarized consent would ensure that the parents are aware and involved in helping their daughter with a life-altering decision. I believe this is a common sense change that provides an additional level of protection for the pregnant minor, the unborn child, and the right of the parents. This bill also has a provision that if a minor desires to seek a judicial bypass, the pregnant girl is assigned to a confidential hearing within a court in the county where she resides, and this just ensures that the judgment is based on the merits of the case. This bill also requires that a judge have a clear and convincing evidence that a pregnant minor is sufficiently mature and well-informed to decide whether to have an abortion before a bypass order is granted. Such a standard would ensure that a judge does not prejudge his request, but considers each on the merits of the individual case. And I will open up to any questions.
Thank you, Representative. Are there any questions from the committee? Yes, Representative. Proceed.
Thank you, Mr. Chair. Good afternoon, Representative. Do you have any exemptions in your bill for rape or incest?
No, if there is the exemption in here is if there is a medical emergency, the doctor can go ahead and perform the abortion, but they are required to notify the parent within 24 hours.
And in that medical emergency, do you know what's included in that medical emergency?
That would be up to the doctor's discretion.
Okay, but there is no exemption if one of the minor's parents, if this is through rape or incest, there's no
Well, this is
exemption.
still we're talking about minor, so whether it's rape or incest, I believe the parents should be informed. If it was an incest, like their parents, or that's where the judicial bypass part comes in.
If you've got time to do that, correct?
I would think that there would be time to do that.
If there is a minor that knows how the judicial system works.
But the court system can help them through that process.
All right, thank you.
Thank you. Any other questions from the committee? If not, Representative, do you have any witnesses here today?
Yes, I do.
Okay, well, how many do we have altogether? Okay, all right, let's proceed.
Mr. Chairman, committee, for the record, Karen Messer. I'm representing Americans United for Life and also Missouri Family Network. The bill before you, as with last year, is not as complicated as it may appear to be. If you think of it in these terms, first off, the primary purpose of the bill is to verify that the parent giving consent for a minor's abortion is actually the parent of that child. Right now, the state has no protocol in place. We have no idea how many minor children are getting abortions in this state where someone pretending to be the parent is the one accompanying the child. This is a severe problem. We have lots of testimonies around the country as well as Missouri where this has occurred, not uncommon. What complicates the bill a little bit is that when we deal with minors and abortions, we have two issues that we have to struggle with, actually three. Representative Newman brought the other one up. One is medical emergencies. So the bill has to address that to stay constitutional, and therefore that takes up more ink. And then there's also the judicial bypass process, and that adds more ink to the bill. So when you read through it and you run into these different details, if you just keep in mind that we're dealing with parents, are they the real parent? And then how do you process that when you have a medical emergency? How do you process that through the judicial bypass system? President Newman brought up the question a moment ago about incest or abuse by the parents. That is addressed in the language of the bill on page 5 at the top of the page. And it does go into that judicial bypass process because that is an issue that we want to be very sensitive to. We also, in establishing these processes, these policies, we also want to hold the physician accountable, that they would certify that the person who presented themselves as the parent presented the proper documentation. So if it's found that somebody was able to circumvent the law, that physician would not be held accountable. That physician, did abide by the law. Additionally, and it goes back to Representative Newman, your question a moment ago, this is why the informed consent and having the patients receiving the abortion, why it's so important that they be put in the room, be presented with all the information. If this is a minor child, they're presented with that information. They have those opportunities then to say that they're being pressured by this person, whether it's a parent or not. So that facility now can engage in their protocol to make sure that this individual is not being pushed into something that they don't want to be doing. With that, I'll be happy to take questions and we can move forward.
Thank you. Any questions from the committee? If not,
Thank you,
thank
Mr.
you,
Chairman.
sir. Good afternoon.
Good afternoon, Mr. Chairman, members of the committee. For the record, Susan Klein, representing Missouri Right to Life, here to go on record in support of House Bill 1968. I won't repeat what you have heard, but I also just want to point out that, these young minor girls are still on their parents' insurance. These parents, we need to make sure that they are the legal guardian or the legal parent. There may be side effects from these abortions once the young girls go home. And if the parents aren't aware that the young girl had this abortion, then there's serious risks there. So we just want to make sure that the parent or the legal guardian is actually the one that's acknowledged as the parent.
Thank you. Are there any questions? Thank you very much.
Thank you.
If you'll leave your witness. Thank you. Good afternoon.
Good afternoon, Mr. Chairman and members of the committee. Samuel Lee with Campaign Life Missouri. We want to go on record in support of this legislation and thank the sponsor for bringing this forward again. And we want to focus in on two things. One has already been talked about, is on page 3, lines 67 through 71, the requirement that there be some government-issued documentation by the parents or legal guardians that they have that relationship with the minor. And one aspect of this I think is very important is that this is just not a pro-life measure or pro-parental rights bill, but is also an anti-human trafficking, anti-sex trafficking bill. There are documented cases in this country of minors who've been brought in by adults for abortions, in some cases forced abortions, who were not the proper persons under the law to do that. I give as an example, in New Jersey about 10 years ago, in the case of United States versus Medrano. This is a case of where 10 defendants, some who were Americans, had illegally brought Honduran women and teen girls into this country for forced prostitution in Union City, New Jersey, which is just to the west of Manhattan, across the Hudson River there. It had, after they got pregnant, in some cases, had required them to have forced abortions. Unfortunately, New Jersey at the time did not have a parental notice law in effect that had been struck down by the New Jersey courts after it had been challenged by the ACLU. So you have an example of some manner, they took them to abortion clinics and without a parental notice law in effect. This type of law here in Missouri would remedy that situation if it has occurred or if it would occur in the future. And then just one other thing I want to point out on page 4, very important provision in the bill, lines 115 through 116, and that is the location where the minor girl would petition a court for consent for the abortion. This is required for the first time that be in the county where she resides. So instead of having a possible assembly line process in the city of St. Louis, for instance, which is the only place that has a functioning abortion clinic at the moment, it would be in the county where she resides, where the alternatives to abortion resources would be available to her, and where the court or the court personnel could say, have you considered going to the local pregnancy resource center or the maternity home or to the domestic violence shelter or whatever it is that the minor girl would need? I think it's a very important provision that this committee should consider. Thank you, Mr. Chair.
Thank you. Any questions from the committee? Representative Meredith, proceed.
Permission to inquire?
Proceed.
On this last paragraph, the county in which the pregnant minor resides.
Yes.
If they get this and they have to go to St. Louis.
Right.
To have the procedure, is there a jurisdiction problem?
In terms of whose jurisdiction?
Well, because the provider would be in St. Louis County or St. Louis City.
St. Louis City, right.
And the pregnant minor could be in, I don't know, some other county.
Well, there's nothing in the law that prohibits the abortion doctor or the abortion clinic from recognizing that court order which gave her consent or which allowed her to have an abortion. I mean, there's no restriction in the law, and the courts in Missouri are required to honor court orders from other jurisdictions within the state.
Okay, I was just want to make sure.
Good question.
Right.
Good question.
Thank you.
Thank you. Any other questions from the committee? If not, thank you, sir.
Thank you.
You left your form, I'm sure.
Yes.
Next.
Joe Artworth with the Missouri Family Policy Council. We would like to register our support for our Representative Anderson's legislation.
Thank you. Any questions from the committee? Thank you, sir. Is there anyone else speaking in favor? I do not know if we do. In opposition, how many people do we have in opposition? Okay. Good afternoon.
Good afternoon. My name is Joanne Schrader, and I won't reiterate what the previous witnesses have said, but I do want to point out that this type of thing happens in non-abortion medical procedures as well. In 2002, when my husband and I took my son to the emergency room for appendicitis, the doctors there made sure that we were his parents and that we had the ability to give consent for him to have emergency surgery. So this is not just something that happens only in an abortion setting, but it also happens in a non-abortion medical situation as well.
Thank you. Any questions? Representative Bratton, proceed.
Thank you. But I think you bring up a great point. As to what other things we do require parental consent. Just a quick lookup of things that require parental consent: tattoos, college applications, any other type of application, trips, camp, a job, bank account, and surgeries. And I think, and even to get aspirin at school, the school will call, I've been called numerous times just to get an aspirin or an Advil from the school nurse. And I think this is a much more high-level medical procedure than obtaining an aspirin from school. And life-changing events. So, yeah, I agree with your testimony and, you know, with this, every bit of what this bill is, as being a parent, regardless of the decision that's made, I think it needs to be a family one. So, thank you.
Thank you. Thank you for your testimony. You leave your witness form. Thank you. Anyone else to speak in favor? If not, we'll move on with opposition. And again, if everybody will leave their witness form.
Good afternoon, Mr. Chair, members of the committee. For the record, Sarah Rossi, Director of Advocacy and Policy with the ACLU of Missouri. I'd first really quickly like to address a point that was just made. There are a lot of things you have to have your parents' consent for, including taking an aspirin, including going on a field trip, including going to school or doing all those other things. The difference between the list that Representative Bratton just made and this particular procedure is that abortion is a constitutional right protected by the United States Constitution. So that's the difference here. Taking an aspirin is a constitutional right. Having your appendix taken out is a constitutional right. So I think that's an important distinction to make. So as far as the new format of the consent and judicial bypass procedures in HB 1968, I've explained to the committee before the standards that are used by courts to evaluate abortion regulations across the country. The standard was set by the United States Supreme Court, Planned Parenthood v. Casey, and that's the undue burden standard, which is that you cross a line with abortion regulations where those regulations will create an undue burden for the woman seeking the abortion. It doesn't matter if the person is an adult or the person is a minor. If it's an undue burden on that young woman or that older woman, it's unconstitutional. I hope you'll forgive me a little bit of levity, but just figuring out how this structure would work felt like a burden while I was reading it. The number of hurdles contained in just this bill is a little bit mind-blowing. So, first of all, the notarized written consent, I'm not sure why it has to be notarized. I don't understand why a parent would have to give a government-issued proof of identity for the parent to prove that they're the parent of legal guardian. You have to show that when you get something notarized. I don't know what written documentation would establish that the parent of legal guardian is the lawful parent other than a birth certificate, which we all know everybody doesn't just have on hand in their filing cabinet. It's not only an undue burden on the minor, but it's also an undue burden on the parents and also an undue burden on the physician in this case. For example, from what I can tell, this bill actually requires the physician who would perform the abortion to go to a pre-petition meeting with the court and the minor and travel from, I guess, St. Louis to wherever the jurisdiction is that the minor is trying to obtain the judicial bypass. And speaking of that meeting, this doesn't require, as the old law does, that you file a petition to get the judicial bypass. This requires that a minor first have a meeting with the court and the physician, and then the court can tell you what the deadline is to file the petition. And then once you file the petition, you have to likely, and especially in rural areas where the judges are going to be more conservative, go through a counseling session, and then you get to have your hearing on your petition, and then you may or may not get granted the abortion. And as far as jurisdiction goes, as somebody else already pointed out, there's only one clinic in Missouri that still performs abortions, and that's in St. Louis. So you're basically asking a minor in any number of rural jurisdictions to take it upon herself to go to her local courthouse and talk to a judge who likely knows her parents and has beer with them on Saturday night. I mean, this has privacy violations that are too numerous to count. Not to mention the fact that if the minor goes and files a petition, or goes and has this initial meeting to be granted permission to file a petition, and then changes her mind and decides not to file the petition, the court has to notify her parents that she didn't file a petition to have an abortion. So if she changes her mind about it and goes to do something else or figure out something else, or maybe even talk to her parents about it, the court has to go and tell the parents that she didn't follow through on her petition. So if she had any privacy left, it would be blown out of the water right then by the court. I mean, the number, there's just too many. I don't even know what to say. But I can't imagine in a world where this many hurdles, this many privacy violations, this many requirements for a parent, this many requirements for a physician, this many requirements for a teenage girl. And by the way, there is no exception for rape in this bill. There's an exception for incest. That's it. There's no exception for stranger rape or acquaintance rape in here. Where a teenage girl who is already deciding to make this decision to figure out what she's going to do in this very difficult situation, I can't imagine that this bill would be held up as something that is not an undue burden on that process. I hope you take that into consideration. I mean, some of it is just so confusing that I don't even want to get into it, but it's a bad bill. It's the textbook definition of an undue burden. I'd really recommend that you don't pass it.
Representative Brad, proceed.
Thank you. Well, in your testimony, you brought up constitutional rights and that the people have a right to an abortion. The right to vote is a constitutional right. Are you able to vote as a minor?
You're able to, no, you're not able to vote until you're 18, but that's in the Constitution.
Okay. What about obtaining a firearm? Can you be a minor without parental consent?
I don't think there's
It's a constitutional right, so I'm just kind of equating constitutional rights
you can't obtain a firearm
as a minor.
Yeah, right.
Without a parental consent.
Yeah. I mean, if we're gonna go through the list of the Supreme Court has actually said
Constitutional rights.
a
You
minor
brought up
has
as
a constitutional right to abortion.
There
The Supreme Court has not
precedent
said
for
that the minor
constitutional
has a
rights.
constitutional right to the other two
There's
we're talking about.
precedent for constitutional rights having parental involvement.
Mhm.
And when we're dealing with the health and I
Voting
think,
doesn't have parental involvement.
uh,
Voting doesn't have parental involvement,
because they're not able to, because they're not of the sound mind and judgment to vote.
which is written in the Constitution.
It is a constitutional right, but there's limitations to that.
Starts at the age of 18.
Exactly. That's what I'm.
The right to have an abortion starts at any age of reproductive when you can actually reproduce.
Oh, have you had children?
Do I have children? I don't think that's relevant, sir.
Well, we're talking about parental rights and having children, you are the legal custodian. So you are basically the spokesperson.
You understand how parental rights work?
Okay, you're not a parent or you haven't answered. So, I mean, would you know?
I understand how parental rights work within the context of
Are
the
you
law.
a parent?
I'm a lawyer,
Okay. So
so I understand how
you're not,
parental
I'm
rights work
taking
within the
that as
context
it's
of the
not
law.
answering, you're not a parent. When you're a parent, you undergo the duty of being responsible for that child, making choices, whether they like them or whether they don't. And some things, that's our duty as a parent in the upbringing. And so, I mean, that's just part of being a parent. They may not like the fact that they have their privacy invaded, but that's part of being the parent and ensuring what's best for that child, because they're not of the sound mind and judgment at that age to make a decision, such as ending a life of another human being. So, thank you.
Thank you. Representative Newman, proceed.
To inquire, Mr. Chair.
You proceed, please.
Good afternoon. My first question is parental consent, is that already state law for?
Parental consent is already state law.
So right now, state law is one parent.
One parent consent with the judicial bypass option.
Okay, well, you brought up judicial bypass, let me get to that in a second. Second, is there any other medical procedures that we know require two-parent consent?
I'm not sure about that.
Maybe I can ask somebody that.
I'm assuming no, since there's so many single parent families, but that's just my assumption.
Okay, because I just want to make sure that we're doing something that is already, precedent for having two-parent consent. And walk me through, I mean, I was a minor. If I was a minor, in a rape situation, I'm, again, a minor. What would my knowledge be of even how to start a judicial bypass? Remember, I've got some limited time here because now I'm finding out that I'm pregnant, and I also know there's a 20-week baby. How am I
I
going
think
to do
that this process, even if it didn't just apply to minors, I think even this process for an adult, 18 or over, would be difficult to navigate and difficult to understand. It would be in the best interest of any minor to actually seek and hire an attorney who would represent her through this process. But again, that's very difficult, and especially in rural counties, you might not be able to find a lot of attorneys who are willing to do it. So without an attorney, the minor would have to know through whatever means that a judicial bypass option is actually out there, and then go to the court themselves and start the process themselves. And ask for counsel if they can't afford it, et cetera, et cetera, et cetera. So it's kind of it's a lot to expect of a teenager.
And so the judicial bypass really isn't an option that we should consider as being feasible, as being logical, that there's enough time to even go from a bad situation to learning of a pregnancy to getting this all done before Missouri will still allow you to have an abortion.
Right. The judicial bypass procedure listed in House Bill 1968 is mind-blowingly confusing.
Confusing for an adult. I don't even understand, where would a minor start? Where would you start?
You have to walk into a courtroom, talk to a stranger, and tell me you need judicial bypass for an abortion.
And that's something that every minor knows how to do.
I wouldn't think so.
So it just seems like that argument to use that as, well, there's protections built into this bill. It just seems like pretty disingenuous. I don't know how most of us would even consider trying to get a judicial bypass.
I obviously feel very passionately about this particular bill. Generally try to stay pretty calm about things, but I grew up in a rural area. Impossible.
Because you don't have the resources, let alone have the funds to know even where to start.
Right.
So the other thing that bothered me, and again, I've waited to ask my medical question, but those might be able to answer. But in terms of, and you brought this up in terms of parents having to prove they're actually the parent. Well, now, because this bill is talking about both parents having to actually prove that that's whatever point they're actually the parent. And then the allegation that this is an anti-trafficking bill, isn't this kind of a reach?
I think that's a little disingenuous, yes.
Because you're assuming with that line that under our current law with the one parent consent, that they may not be the real parent.
I think that's the proposition, yeah.
So, okay, I just want to get your thought on that, because it seems like, we really should not go down that path, because it's becoming very, like you said, disingenuous.
When we have obviously testified in this committee before about the burden that just one parent consent and just the current judicial bypass structure puts on a minor anyway, so obviously we aren't in favor of making that harder.
Adding more burdens, like you mentioned, to a constitutional right.
Right.
Thank you.
Thank you. Representative Lauer, proceed.
To inquire, Mr. Chair, thank you. Actually, I'd like to inquire the sponsor. Okay, thank you. I guess a couple of points. One is, this is a very serious issue.
Yes, it is. We're talking about the life of a child and the life of a mother.
Okay. And as the witness was explaining all the problems with the bill, I read the bill, and the testimony seemed to be overcomplicating to me what's in the bill. So I guess I'm going to look at this from, first of all, we're talking life of human beings here.
Correct.
That's first and foremost.
Yes.
Second part being the process as it's set up. None of this conflicts with HIPAA.
No.
Much of this, as I think Representative Bratton was referring to earlier, is standard procedure or not standard procedure, but part of what we do when we have minor children, to be able to sign off on various things and so forth. So that's already kind of in the game plan. Is that correct?
Yes.
All right. And from the medical side, the physical side, there is certainly always a risk.
Correct.
This
is a serious procedure. It's a surgery.
Yeah. And I don't mean to get on a soapbox here, but I had a DNC that went really, really bad and turned blue and started to die.
Oh my.
And when you're laying there fighting for your life, that's a DNC. And you don't know what you're doing. To make decisions, to all those kinds of things. And when you are truly on death's bed and you know it, and there are things going on, it's very, very difficult to process everything that's going on. So, and I'm not trying to over dramatize, I'm sorry if I'm getting a little wound here, but my point is that these are very serious surgeries, just in and of itself from a medical standpoint. There are things that could possibly go wrong, in which we need people there who can provide the consent, who can provide
Right.
decision-making, clear decision-making.
That way the parents can make sure that they get the proper medical attention they need.
Okay. So given all of that, then we come down to the steps that need to be taken. And as I read through this, the notifications, the keeping of the records and so forth, part of it certainly is for the protection of the physician.
Yes.
Part of it is to make sure that there is nobody going back at any part-time saying, I didn't say that, I didn't do that, that there's a clear track record of the decision-making process,
Yes.
so that as everything is going on, from just a liability standpoint, that's all pretty crystal clear as to what's happened, what's gone on.
Yes.
Okay, so my point, as we kind of walk through all those pieces, this has many components to it. It's a very systemic issue. But overall, the intent of your bill is to make sure to address the constitutional right of everybody to have life and liberty and so forth, but also to make sure that there's safety involved, protection, liability, and so forth, and all that sort of thing, and that the integrity of the medical information, HIPAA, and all that stuff is maintained. Is that a fair assessment?
Yes, I would agree with that.
Okay. Thank you, Mr. Chair.
Thank you. Is there anyone representing them? Proceed.
Yeah, thank you, Mr. Chair. Just to follow up on the comment when we were talking about HIPAA, can the witness actually, can you describe what you're talking about in terms of privacy concerns? Because I'm not sure that we're on the same page here.
My privacy concern is on page 3, section 6, subsection 1. It reads, consent shall not be required if the attending physician certifies in the minor's medical record that a medical emergency as defined in section, et cetera, exists, and there is insufficient time to obtain the required consent, except that the attending physician shall, within 24 hours after completion of the abortion, notify one of the parents or legal guardian of the minor in the manner provided in this section that a medical emergency abortion was performed on the minor and in the circumstances of warranted indication of this section. So basically, if a minor goes and seeks an abortion and it's a medical emergency, it's their constitutional right to have that abortion because of this medical emergency, and then the physician then has to turn around and tell the parents, regardless of whether or not the minor told the parents. And I said, that might be a HIPAA violation, because I can't imagine that it's okay to divulge medical information that is supposed to be kept confidential to a minor's parents when she has obtained a procedure within her legal rights, which a medical emergency abortion is.
Thank you for clarifying.
Yep.
Thank you. Representative Brown, proceed.
Thank you. Just one little statement. There was a comment made that there was not a belief that human trafficking or sex trafficking probably wouldn't be affected, that the results of it wouldn't occur in this situation as the impression I had. I'm on a task force on human trafficking, and we went around the state. Any number of times we were hearing stories. Now, maybe they're just stories, but stories about young girls who were sex trafficked and then forced to have an abortion. Now, were they forced to have an abortion? How did that occur? What kind of, did someone go in and say, this is my parent? I don't know. But if this, having it notarized will ensure that that doesn't happen, then that's all it takes for me. Thank you.
Thank you. Our chair is back. Do you want me to continue, or do you want to? We're ready for information, or unless there's anyone else speaking in opposition or removing it. There is.
Good afternoon, representatives. Thank you for giving me the opportunity to submit testimony in opposition to HB 1968. My name is Allison Dreef. I'm the Executive Director of NARAL Pro-Choice Missouri, a statewide grassroots organization with more than 40,000 members dedicated to promoting the full and equal access to reproductive choices, including preventing unattended pregnancy, choosing safe and legal abortion, and bearing healthy children. On behalf of NARAL, I urge you to oppose HB 1968, sponsored by Representative Anderson. I was going to talk to you more a little about the problems with judicial bypass, but since we heard that prior to me getting up here, I just wanted to add something small that the representative from the ACLU did not mention. And denying a petition to one young woman in Missouri, a Missouri judge stated, because we do already have parental consent and judicial bypass on the books in the state, quote, depending upon what ruling I make, I hold in my hands the power to kill an unborn child. In our society, it's a lot easier to kill an unborn child than the most vicious murderer. I don't believe that this particular juvenile has sufficient intellectual capacity to make a determination that she is willing to kill her own child. So that really goes back to what Ms. Rossi stated earlier about the judges that minors might come across in this type of proceeding, that only certain kinds of judges hear these cases at certain times of the week. And in rural parts of Missouri, we would probably tend to see a lot of judges who might believe the same way that this one Missouri judge did, and rule depending on his or her own beliefs and not the Constitution, putting that child maybe at risk in a number of ways, not only from rape or incest, but also of pregnancy itself. Pregnancy is a dangerous procedure. It's more dangerous than abortion itself, and that risk goes up even higher when we're talking about a minor, especially at the age some girls are getting pregnant these days. So I just wanted to leave that for your consideration, and I'll leave the additional judicial bypass stuff here for you to read on your leisure. Thank you.
All right, are there questions for this witness? All right, seeing none, thank you. Others in opposition? I'm going to go ahead, how many more in opposition, please? Okay. We have another bill here, so we're going to.
Understood. For the record, my name is Maggie Mead, and I'm with Planned Parenthood Advocates in Missouri, and we work with and represent the 2 Planned Parenthood affiliates in Missouri who serve over 60,000 Missourians, primarily with preventive care, access to birth control, cancer screenings, sexually transmitted infection screening and treatment, and we also provide access to safe legal abortion. I have written testimony that covers the basic facts, some of which have been covered already. I'll submit that with my witness form. But I did want to address a few things that I heard that might be helpful to this committee. First off, I've sat in several of your hearings and heard the very thoughtful questions that you ask when the issues of the challenges of parents and families and what exists in this state. And I believe that this committee demonstrates the core value that Planned Parenthood shares, which is that we all want our teens to be healthy and safe. And that especially this committee has heard some really troubling situations when families are not functioning in a healthy or safe capacity. And so the major medical organizations that work with adolescent health care oppose forced parental involvement laws when it comes to the area of reproductive and sexual health, out of that core value that you share to keep teens healthy and safe, because in certain circumstances that you've actually heard described in some of the previous hearings, when families are not working, when there's abusive, when there's physical, mental, other types of abuse, that the parental involvement could actually cause harm to the teen. The current law that I've spoken about before, what we believe is a misinformed consent process already, we feel is designed to shame and coerce women seeking abortion of any age, and adding these additional hurdles that have been described, we think would put teens in more danger. To address what's going on currently, in the current Chapter 188, as I'm sure you all have seen, there are penalties for violating any section of it. So in current law, it is mandated that one parent of the minor consent, or that there's a judicial bypass process used. That all needs to be documented in order to comply with Chapter 188, and the consequences are high. There are lots of license and a misdemeanor. So the current process in Missouri already comes with consequences and is being closely adhered to, and that there's not been documentation. I've heard some references to some cases that sound terrible but not on point in terms of what's going on in Missouri right now. And I think those were the questions that I had heard that I wanted to help address. I know you've got another bill, and lots of people want to speak on that. I'd be glad to take further questions, and we'll submit my testimony.
All right, thank you. Questions? Representative Brett.
To inquire.
Yes.
Now, we've heard testimony about trafficking, human trafficking, and I know we've dealt with that for years, of the problem that is that's occurring in Missouri of sex trafficking. Now, with current statute, there's no requirement of proving that you are a parent. So if we have somebody who's a sex trafficker bringing in a young adolescent for an abortion and no ability to vet who that person is, then they're dropping that person off, getting an abortion, signing off, yeah, this is who I am, and then they're gone and you don't see them again. I mean, how can we follow up on that?
So the documentation, in order to comply with the current statute, where the current statute says that it must be a parent, so we document that it's a parent.
We know people with ill intent and trying to break the law. They, if there's nothing, no teeth or no real verification of who they are, how do you catch them?
So loss of license and being subject to a misdemeanor, I would consider teeth, and that the providers take very seriously. And the Department of Health and Senior Services, when they do surveys or inspections, or the regulators are observing whether the entity, any ambulatory surgical center, is following the law, that's part of what they are looking into, is that you follow all those different pieces of the law.
But what must be submitted as proof that they're the parents right now?
So,
the family situation, that you brought up with troubled family, I mean, people with different names and things. So how would you cross-reference that without?
So I'm going to give you a sense of the process, and then I will come back to you and confirm. But so a birth certificate, where the names are the same. As you mentioned, many situations where the names are different, then the providers get the trail of documentation for the name change, and then legal guardian or legal documents associated with that. So I may not have covered every single situation, which is why I will double check and get back to you, but those are the types of documentation that the providers use to comply with existing law because of the penalties associated with existing law.
Okay. All right, thank you.
Mm-hmm. Other questions, Representative Newman?
Yes, to inquire.
You may. You may.
Thank you. Just wanted to follow up with the question I had about medical entities and how do they, feel about, us requiring, forced parental consent here.
So ACOG, the American Academy of Pediatrics, I believe the American Academy of Family Physicians, all oppose actually the existing parental involvement because they have found through surveys and evidence-based documentation that the parental involvement around the areas specifically related to sexual and reproductive health become barriers for minors seeking care. And it is the medical professionals' belief that the access to care is the most important thing to keep minors healthy and safe. And actually, I did want to go back and, if it's okay, reference the questions about HIPAA. I'm not a HIPAA expert, but there is an area in HIPAA rules that do take into account minors' confidentiality or ability to have confidential treatment and therefore consent to treatment when it comes to sexual and reproductive health, for the very reasons I just said that the major medical organizations also cite for the promotion of access to care. So there are rules specifically around HIPAA, and I do think the way I understand it is that the federal rule sets the floor and states can go above it in terms of protecting confidentiality, but it can't sink below it. And if the minor has gone through the judicial bypass process and then has been approved to seek care, the notion that then the state would notify the parent when the minor has the right to give consent to the care, then I believe it would be a violation of HIPAA, although again, I could go back and check, but I did want to clarify that HIPAA has made specific references to confidential care that minors should get in this area of sexual and reproductive health.
Well, and I find this very interesting. I mean, this proposal basically is kind of, it is mandating a certain level of medical care. And yet, I mean, we do this all the time, but yet the medical professionals are telling us that no, that this would be actually harmful. And so I just want to point that out, that you've got several, national medical associations that are saying no, that even current law is not good for, like as you pointed out, for our teams. And so yet here is another bill that we're intending to put some more restrictions, and that actually that's really putting these minors at harm. Right, they're putting them at risk.
That is our concern. We want teens to be healthy and safe. The major medical organizations, through survey and evidence-based experience with minors' access to this kind of health care, say that this level of regulation is not only not necessary, it's harmful. And so that is why we oppose this bill.
So, well, thank you. I think this committee needs to be very careful when we're making additional medical policy in the state, which the medical experts are saying is very risky. I think we have a duty to pay attention to that, particularly since we don't have a OBGYN here on the committee to be able to weigh in. But I want to thank you, because I think what we're if the whole intent behind here is to keep our minors safe, then this bill does not do that. We don't. So, thank you.
Representative Bratton.
Just a quick follow-up, Madam Chair. I hear this about infringing on the minors, privacy. But in regards to any type of surgery, if we, the parent, did not know that surgery occurred and something went wrong to where we had no clue, this would then put that minor in peril, in their life in danger, because we had no clue, because we were removed from a major medical procedure. And so you say this is we hear this as protection of that youth, when indeed this may actually result in the death of that youth if something were to go wrong.
So just
because that OBGYN at a Planned Parenthood isn't doing a follow-up or any type of, there's no follow-up procedure. So, I mean, if this abortion occurred and say there was a part or a tool or something still remained and started to decay and die within that child, causing that child to shut down, to die, and we as a parent have no clue what in the world is going on. Do you see that would be a conflict in helping that child?
Well, let me just clarify a couple things. One is that abortion is an incredibly safe procedure. The Center for Disease
But accidents do
Control.
happen. Medical malpractice is a very, very big deal. Would you not agree?
So it's a safe procedure with a 99% safety record from the Center for Disease Control. There are policies and procedures for follow-up. It's all a part of delivering high quality reproductive health care, so that question that you're asking is addressed, that the symptoms that would be associated with that would be considered as and addressed as part of follow-up care. The scenario is
You
that.
say that 99%, but I would sure hate to be the parent of that 1% that loses a child because they weren't informed.
So that once you get past the 99%, there are a variety of different complications. The complication rate doesn't necessarily mean death, but in the situation where there could be something, and
Or completely render that child, when they grow to be an adult, can no longer have a family of their own. I mean, that would be detrimental at the mental stability of a human being. Would be, not to mention, I haven't even got into the mental tenderness of a child.
So I think these are the reason that both in the law and the medical scenario that reproductive health care is treated with some unique special attention. It's because, think about the risk associated with childbirth, which is the alternative if the minor can't access an abortion, if that's the course of treatment she chooses. So the risks associated in that situation are significantly more. In the situation that the representative shared, where there's an emergency situation, it's addressed as an emergency situation where there aren't barriers to healthcare that is needed by the individual in an emergency situation is provided. And so
I just don't see that good policy or even thought to leave the parent, the one that's caring for that child, completely out of it, regardless emergency or not, with a procedure like this.
So again, I appreciate the picture of a family, of the kind of concern you're demonstrating. And fortunately, I think that is the majority, which is why the majority of teens seeking an abortion do involve a parent. The major situation I'm trying to address has to do with in families where the communication is not good and there is violence and abuse.
Or they're just afraid of confronting the parents, so they automatically, try to save face and go through a procedure, and then leaving a parent out, and we've now allowed, the parent to be left out, and could result in something severe occurring to that person.
So I think that is why the major medical associations, when they look at the medical evidence, find that the barrier to care for the minors with the parental involvement hurdle have a much higher cost in terms of health outcomes. So it's much more dangerous to force the minor into one course of care or another through the parental involvement. What I think the impetus around parental involvement is trying to nurture strong Missouri families. And I don't think restrictions like this are the way to go there, which is why we're opposed to the bill.
All right, thank you. You've cited different organizations that you're relying on for your information. Would you provide those to the committee, please?
The names of the organizations, the national.
Your specific.
Yes.
Your specific information.
Yeah, I will do that in follow-up.
Thank you very much. All right, is there any other questions for this witness? Seeing none, are there others in opposition to the bill? Seeing none, is there anyone here for informational purposes only? Seeing none, Representative, do you have any closing remarks?
I do. Thank you very much for taking this time to hear this very important bill. Again, I'd like to remind you that this is strengthening the parental consent law. We're talking about teenagers who don't always make the best choices. And this is a very traumatic decision. We want to make sure that the parents are aware to make sure that they get the best medical attention that they deserve. We're also talking about the life of an unborn child. I mentioned they brought up about constitutional rights. What about the constitutional rights of that unborn baby? We're talking about removing a baby, killing a baby, terminating that life from the womb. So yes, this is very serious. And to talk about judicial bypass and how this is just an inconvenience, we're talking about the life of a child and the life of the mother and parental rights. Thank you.
Thank you very much. So that concludes our hearing on House Bill 1968. Now, Representative Swan, would you please come forward? And we would like to hear House Bill 2055. You may proceed when you're ready.
Thank you. Good afternoon, Madam Chair, members of the committee. Thank you for the opportunity to hear this bill this afternoon in your committee at Swan District 147, Cape Girardeau. This is the second year regarding this issue, although this bill is quite different from last year's. As we go through this, I would also ask that you refer to an amendment, a proposed amendment, that you should have a copy of as well as the original bill, which is House Bill 2055. The definition of a family is a group consisting of parents and children living together in a household. But not all families are fortunate to have both parents living with the children. I had a childhood friend named Martha. I lived 2 doors from her. She never knew her father. Her father and her mother met while they were both serving in the Navy. Her father was shot down over Korea within a couple of days of Martha being born. Her mother never remarried. She wasn't totally alone, however, or without help. Martha had the benefit of loving grandparents, or paternal loving grandparents, who played a very major role in her life and the lives of her 2 older brothers. But that was 60 years ago. With the divorce rate having escalated from around 15% in the 1950s to nearly 50% today, and the common practice of awarding significantly greater custody to the mother, we may have inadvertently increased single-parent households. Plus, an unintended consequence is a shutting out or perhaps a disregard of one set of grandparents, furthering the fracture of the family. Children of single-parent families are at greater risk of teen suicide, dropping out of high school, substance abuse, imprisonment, behavior disorders, and homelessness, resulting in a lifetime of social problems. Our existing family court system has resulted in a reduced ability of the father to be an important part of his children's lives. At the same time, the system is restricting children with imposed limitations on access and opportunity with both parents, and as a result, the grandparents as well. Parents may not be encouraged to complete a parenting plan to submit to the court. Completed plans may not be considered by the court or may not be awarded without a documented reason. As a result, one of the parents, mostly the fathers, may be denied a substantial opportunity to parent their children. Even if the father wishes a shared parenting plan but the mother does not agree, the precedent has been set to favor the mother in the custody order. Many states have begun to recognize the need to rethink how custody is awarded and the resulting impact on children and families. Changes in our legislation are needed to reset the expectation of our family courts, to reset the default, to maximize parenting time in the best interests of the child, not an automatic default of 1 day a week and every other weekend for fathers. Primarily, our laws are created to deal with the bad actors, not the good ones. But we have created a dysfunctional reality where sometimes children become the prize in a game of tug of war. Status quo is unacceptable. And we can either deny the problem or we can fix the problem. Our children and our grandchildren and grandparents deserve the fix. The bill does not mandate a 50-50 parenting arrangement, nor to remove or minimize the judge's right and responsibility. It simply resets the default. From the assumption that the mother should be granted the most time with the child to the assumption that shared parenting is truly the most beneficial for the child. A simple change in the parenting form and encouragement by the courts for parents to set aside personal differences and act in the best interest of their children is truly the best. This bill is not about lawyers. It's not about courts. It's not about judges. It's about Missouri children and families. All Missouri children and families, regardless of which side of the state on which they live, or regardless in which county they live. The proposed amendment before you addresses the Missouri Supreme Court establishing a parenting plan form. It also allows flexibility in the plan